Well, I'm thrilled that Gary Stein has joined us here today on Wrecking Ball, which is a series of the Historical Society of the New York Courts podcast, where we consider the tales behind preservation, the law, and the cities within New York State that we love. And it's interesting that Gary Stein has joined us here today because he has written a new book, where the courthouse is one of the characters. But the central figure in this book is a gentleman who I envision in a cartoon that you sort of find in the middle of Gary's book, which is entitled Justice for Sale, where there's a judge sitting up on his bench. And below that bench is a different bench with a ladder, and it's labeled Personal Holding Company. And below that is another one that says Private Corporation, and another one that says Loans Accepted. Gary, what on earth am I talking about here, and who on earth am I talking about?
Well, that's a very good image, the cartoon that you point out that ran in January 1939,
Yeah.
when Judge Martin Manton's secret life, essentially, as a corrupt judge, was exposed to the public as a result of an enterprising reporter at what was then the New York World Telegram. And the cartoon is very apt. Manton was not just the judge on the Second Circuit, he was the senior circuit judge and had been so for 12 years, had been a federal judge for 23 years almost. He was the youngest judge appointed to the federal district court back in 1916. And by the time of that cartoon, he had essentially built an empire based on corruption. This was the era of the racket, underworld, everybody exacting tribute in all sorts of different businesses. And Manton did that in his own way as a judge. He was essentially running a justice racket, and he was sitting on top of it. And it was not a one-man band. He had a whole network of fixers who went out and solicited people to pay bribes. And of course, all of the various people who paid bribes were part of the scheme as well. So it was kind of a vast enterprise, as that cartoon depicts.
And it's set in this very unique crucible of New York City history, because the cover of your book, Justice for Sale, has this picture of Judge Manton right next to a picture of that monumental courthouse at 40 Foley Square by Cass Gilbert, the same architect who designed our Supreme Courthouse of the United States. Tell us a little bit about Foley Square and this sort of seedy, rackety underworld of New York where Judge Manton operated at the time.
Well, where Foley Square is currently situated used to be known as the Five Points district of Manhattan, which was just a den of iniquity back in the 19th century. You had all sorts of hoodlums and gangsters and vice of every conceivable description taking place there. That ultimately was reshaped largely by the building of courthouses, not just, of course, the federal courthouse at 40 Foley Square, but also the state courthouse at 60 Center Street and the other public buildings that sprouted up and eventually evicted the various characters who once prowled the Five Points district. And really the Five Points district doesn't exist anymore. But it's interesting because Manton, in a way, shows that some of the characteristics that prevailed in the Five Points district didn't go away just because this monumental federal courthouse was built in Foley Square, which, by the way, Foley Square itself is named after a Tammany politician named Tom Foley.
Big Tom.
Big Tom, who, it should be said, although he was very much a part of the Tammany machine and helped run the machine, he personally did not, it appears, profit in the same way that most Tammany politicians did. And Manton really followed in that tradition of a Tammany politician. He had sort of grown up in that community, and he viewed public office as an opportunity not just to serve the public, but to line his own pockets, unfortunately. But that was sort of understood and even not denied by the Tammany politicians of the era. They sort of were made no bones about the fact that they use public office as an opportunity to make some money.
Exactly. And he was in this sort of mix, but then there were other landmarks in his life as well. He lived on this Long Island estate. He had investments in hotel properties. He was involved with the founding of the neighborhood of Forest Hills, which of course today is portions of it are landmarked as well. Tell us more about his reach, his tentacles throughout New York City and state.
It's pretty amazing. I mean, you have to give him credit for having a lot of energy. Here, a federal judge. He actually wrote more opinions on the Second Circuit sort of, per annum than any judge in its history.
Wow.
And he was also, as the senior judge, saddled with all these administrative responsibilities. He was a very active participant in the Catholic Church. He was knighted by the Pope at one point. And on top of all of that, he basically ran his own business enterprise as a judge and owned interests in all sorts of companies. Real estate, as you said, a couple of significant apartment hotels on the Upper West Side, a company in Syracuse that made sanitary napkins, among other things, a milk bottling company, laundries, and on and on and on. We don't expect that from our judges, from our federal judges in particular. And back then, it did stand out. Certainly his colleagues on the Second Circuit, the Han cousins, Thomas Swan, did not engage in such activities, but he did on a very large scale. And ultimately that helped get him into trouble, because when the businesses started failing and the real estate investments started going south after the crash of 1929, he resorted to raising money from litigants and lawyers who were appearing before him.
Right. And you're saying quite euphemistically, he's raising money from these litigants. He used another euphemism that he favored. He would call them loans from folks who had business before the court. And yes, Manton was this prolific author of judicial opinions, and he was the chief and all that. But you share an interesting anecdote in your book where you say that folks who are clerking within the Second Circuit today are expressly instructed never to cite a Manton opinion. And it sounds as if he was also a notoriously bad writer at that. So two reasons not to cite him: the dustiness of his prose, but also his criminal conviction. So you've set the stage for us of the pressures on Manton during this Great Depression era, where he looked for these loans and other emoluments. But tell us the central controversy that ended up bringing Manton down. What was this criminal case that he faced ultimately?
Well, the criminal case that he ultimately faced was based on 6 different cases where he had taken loans or just outright payments or bribes. Most of them were patent cases where he took money from one side. One of them was a criminal case, actually, where the defendant was a patent lawyer who had bribed Manton by making loans to him in connection with appeals he had before the Second Circuit. He happened to be the chairman of a Brooklyn bank and arranged for the bank to make loans to Manton right at the same time Manton was presiding over those cases. And then he got in trouble himself and was charged with, of all things, bribery, and went to see Manton to see if Manton could help. And Manton said, yes, I can help. I will bring in a district judge from Connecticut, and he will get rid of your case for the price of $10,000. And that's what happened. The patent lawyer, his name is John Losh, went to Manton's chambers with the cash, delivered it to him there. Manton dialed up his safe. He actually kept a safe in his chambers in 40 Foley Square, and he tucked the cash inside. And then the judge was brought in from Connecticut, granted a motion by Losh's lawyers to dismiss the case after the jury was impaneled. So the government had no right of appeal. Those were the cases that the indictment was based on, but it really is just the tip of the iceberg. There were many other cases where Manton took payments, loans, bribes that were not part of the charges at the trial, and those have come about in part from the cross-examination that did take place at the trial when Manton testified, in part from subsequent discoveries, in part from research that I did in connection with the book at the National Archives that revealed schemes that have never before seen the light of day, to my knowledge.
Oh my goodness. It's so sprawling and so brazen and so bold, especially when you consider all of the other areas where his fingers were involved, right? I mean, he's this figure who's this procedural master, and you just described the way in which there's a jury impaneled, but he makes a decision and there's no right of appeal. And he's essentially getting people stuck with whatever his corrupt decision is. How else was he this procedural master in locking in these victories for his corrupt clients?
Well, there's a almost comical incident which I relate in the book involving one of these patent cases that was the subject of the trial, where the lawyers for the other side, they actually represented the Schick razor company, which was bringing a patent infringement suit against another company. And the executive at the other company, sort of a wily entrepreneurial type named Archie Andrews, was paying off Manton. And the lawyers for Schick, who were pretty savvy, suspected this at some point. And when the case was scheduled for argument in the Court of Appeals, they tried to, it was initially set on a day when Manton was one of the judges sitting. They tried to move it to a different date when he was not sitting. And they actually got the support of the lawyer for the defendant, who evidently was not in on the scheme. And the lawyer for the defendant said, "Oh yeah, that's fine. We can move it to that date." And Manton looks at the lawyers for Schick and says, "No, we're not going to do it then. We're going to keep it on the date that I want." So, one of the sort of, oddities and mysteries almost in a way of Manton's corruption is that he was an appeals court judge. And of course, federal appellate courts then, as today, sit in panels of 3. So his vote alone could not tilt the case one in the direction of the person paying him the money. He needed the support of at least one other judge, but he was able to use his administrative powers to help shape the outcome of these cases, for example, by sitting on the case. Another area where he did that is he had a practice of appointing himself as a district judge to preside over big equity receiverships at the time, the equivalent of what we would call bankruptcy today. And there he really had all the powers of a district judge and would do things like, for example, steer contracts to firms in which his relatives had an interest, his sister and niece. And it was just a basic kickback scheme that he was able to engineer from his perch as a district judge in those cases.
Wow, a procedural master indeed. And speaking of relatives, some of my relatives play a little bit part in your book as well. Because of course, Manton at this time, he's involved with railroads a bunch, right? We're all familiar with everything that railroads did to build this country, and Manton's involved in Long Island Railroad tort cases. There's a bit of a bribery in a parlor car on the Long Island Railroad that you describe. And he's also involved with the subway system in New York, where my great-great-grandfather and his son, my great-grandfather, so Samuel Untermyer and Erwin Untermyer, were trying to keep this 5-cent fare for the subways in New York to keep things sustainable for the riding public. And there's a longtime family legend about what I think it was Mayor LaGuardia called the judge who lost his head and signed the order, basically lifting the 5-cent fare. This case ends up at the Supreme Court, and Manton's panel is reversed, I believe. Tell us a little bit about that episode with Samuel Untermyer and Manton and the Transit Commission and the 5-cent fare.
Yeah, and what's really interesting about this case, which was not part of the trial, never anything that he was actually charged with, is that it took place in 1928. So this is before the crash of 1929. And Manton has generally been viewed as someone who fell prey to the depression and the financial pressures that put on him to resort to corruption. And I alluded to that earlier in this podcast, but that's not really the full story, because in this case, 1928, which was a hugely important case, the IRT was challenging the constitutionality of the 5-cent subway fare. And Manton was on a panel, a special court, a three-judge court that heard the case. He wrote the opinion. He wrote in favor of the IRT and the other subway company that was a party, and said, yes, this is confiscatory under then prevailing Supreme Court precedent, and the 5-cent fare should be no more, notwithstanding the fact that the subway lines had agreed to it in their own contracts with the city. Just a few days before that case was brought, Manton took a $75,000 investment from a lawyer named Thomas Chadbourne, with whom your great-great-grandfather, Samuel Untermyer, had clashed at a public hearing, your great-great-grandfather having represented the Transit Commission. And Chadbourne had a substantial financial interest in the railroads, and he wanted to get rid of the 5-cent fare. It does not seem like a coincidence that just before the suit was brought, he arranged this $75,000 investment, which of course, back at the time, that's more like, $1.5 million today in one of Manton's companies. I view that as an early case and a pre-crash, pre-depression example of Manton's corruptions. It was all done sort of in secret. There were sort of nominee directors appointed who were functionaries at the Chadbourne law firm. And by the way, this is Thomas Chadbourne of what became the Chadbourne Park, one of the great law firms in our city. And I didn't realize this actually till I was researching your family for this podcast. But as you mentioned, the Supreme Court ultimately reversed Manton's decision. And what I had not realized is that although your great-great-grandfather, Samuel Untermyer, had sort of led the charge in the litigation and representing the Transit Commission, he got sick before the Supreme Court argument.
Yes.
I don't know if you know this.
Yes, I do.
And your great-grandfather, Irwin, actually conducted the oral argument and won.
Yeah, and the story goes that there were only 2 interruptions during oral argument, and that was to request page numbers in the brief. So something tells me it was a rather straightforward case, hence LaGuardia's comment about the judges having lost their heads or taking investments, as Manton may have called it.
Yeah. Yes, it was a very unusual case in that regard. Ultimately the Supreme Court said, well, this really belongs and should be decided by the New York state courts. Mm-hmm. And every single state court and every single judge on every single state court, all the way up the ladder that considered the issue, all ruled against the IRT and the transit companies and in favor of the 5-cent fare. And it's, Manton grew up as a political, progressive. Essentially, his practice. He did not represent corporations. He sued corporations. He was had a big personal injury practice, and he was a big supporter of President Wilson and sort of a thorn in the side of corporations. And here we have this case where he rules in favor of the corporate interests in a way that was obviously against the wishes of the Tammany politicians like Governor Al Smith. But I think in this particular case, whatever ideological and political leanings Manton had were shoved aside by his financial self-interest.
Yeah, and I have to tell you that is one of the joys of this book, because whether it's a family connection or a preservation connection, whether it's a legal issue or anything else, there's so much for people who are historians, historically minded, to connect with in this book. And I wonder what drew you to this subject matter. You've obviously been in and around the circuit your legal career, but why Manton and why this book and why now?
It's a good question, and the answer is kind of lost to the time. I started this a long time ago. And I mean, the short answer for why I started it, I think, is that my kids grew up and went to college, and
right.
This became sort of my project on the weekends. I remember Manton from law school. I remember hearing about him. I bought a book called The Corrupt Judge, which was written in the 1960s by a former DOJ lawyer, which is about Manton, but also 2 other judges who were involved in various corrupt schemes at the time. And it sort of intrigued me. It's a good book, but it really just sort of recites what happened at the trial and in those 6 cases. It didn't really address who Manton was, where he came from. What motivated him to do this? A federal judge, senior circuit judge on the Second Circuit. And it also didn't really say anything about the people who were paying him bribes, which I was also interested in because, it takes two to tango to commit bribery. So I was also interested in knowing who those people were and how they had come to commit these acts.
Right. And, Manton, he's remembered for this corruption. He, of course, is convicted. He serves his prison term, I believe. How does he end his life?
He ended his life, really quietly. After he was released from prison in, I think it was 1941, he left New York. He moved out near Syracuse, where his son was running this sanitary napkin company that I mentioned before. And no one really heard much from him. And he passed away in November of 1946. The obituaries were, not exactly what he had hoped for when he was sitting on the Second Circuit.
Right. And it's a tangled and tumultuous legacy, but we're so grateful that you've brought it to light for us today. And I think a lot of us, after reading this book, will be wondering, could it happen again today? What are your parting thoughts on that point?
Judges are human beings.
Right.
Of course it can happen again. We tend to deify judges, I think, on both sides of the political spectrum. Ronald Dworkin, who was one of my professors in law school, had this whole thing of the judge as Hercules, sort of this omniscient, super person. And then you have Chief Justice Roberts, on the other side, having this ideal of the judge as an umpire who just calls balls and strikes, sort of an automaton that is devoid of any, sort of personal beliefs or passions or prejudices. And neither of those images is realistic. Judges are human beings, and this book and Manton really reminds us of that, and I think we should be reminded of that.
Well, I'm not just saying this because you gave me loans or investments, but it's a fantastic read. The book is Justice for Sale: Graft, Greed, and a Crooked Federal Judge in 1930s Gotham, and we're so pleased it's brought Gary Stein to us. We're going to take a brief break, and when we come back, we will enjoy our favorite segment, your Daily Ada Louise. Please join us just after the break.
Wrecking Ball is brought to you by the Historical Society of the New York Courts, which is dedicated to preserving just that, New York's vast legal history. For more information about that important group, just Google Historical Society of the New York Courts or visit history.nycourts.gov.
Well, welcome back, everybody. We are here with Gary Stein, the author of Justice for Sale: Graft, Greed, and a Crooked Federal Judge in 1930s Gotham. Gary, the book is just fantastic. And before we let you go, we want to make sure that you participate in our little segment that we call your Daily Ada Louise, which is a tribute to a great lioness in the city of New York and the state of New York who cared about preservation, the law, and the cities where it all takes place. Ada Louise Huxtable, of course, that longtime New York Times architectural critic with so many legendary quotes about the built environment of our city. And Gary, I asked you to bring along a quote that might resonate with you. Do you want to tell us a little bit about the quote and why you picked it?
Yes, I picked it because it resonates, to me at least, in terms of the Manton story and what you alluded to before, which is the way in which the courthouse itself, the federal courthouse, became sort of a character in the book and was actually sort of a character at Manton's trial. Let me read the quote from a November 1974 article by Ms. Huxtable in the New York Times. And she wrote as follows: "The public building that serves and symbolizes the institutions of government has always striven for dignity, monumentality, a suggestion of art, and an indication of the nobler aspects and ideals of man. Or it did until recently. One look at most of today's public buildings suggests that somewhere on the way from the 19th to the 20th century, a lot of values got lost." And then skipping down, she continues, "What goes up in their place, in the place of these monumental government buildings, can rarely be differentiated from average, read cheap, commercial construction with a sign over the door to tell the visitor that he is indeed in City Hall or the seat of country or state government, or a place where the ideals and processes of justice are housed." And then she adds in a parenthetical phrase, you can hardly blame him if he begins to wonder if the ideals and processes are any better than the building.
Mm.
And so, she suggests that the sort of association between the nature of a public building, including a courthouse, and what goes on inside. And I think a lot of us share that notion that a lot of the courthouses are built in this classical style that evoke what Ada Louise called the ideals of justice or the majesty of the law. And certainly the U.S. Supreme Court and the federal courthouse at Foley Square, both of which, as you pointed out, were designed by Cass Gilbert, are great examples of that. And the federal courthouse is fronted by these 10 sort of 4-story massive Corinthian columns, and you walk up the granite steps, and which of course I've done many times as a lawyer, and it does give you a kind of charge. And it really, I think, played a role in Manton's trial because Manton's prosecutor, who was John Cahill, founder of the Cahill, Gordon, and Reindel firm, essentially made it into a inanimate character witness for the prosecution.
Yes.
In his closing statement, he talked about how brokers and brewers and moneylenders were lugging cash into this very courthouse, and how Manton had turned it, instead of a courthouse, into a counting house. And remember that's the very courthouse where the trial was held, and it's the very courthouse where Manton did everything that he did. That's a slight exaggeration because that didn't open until 1936, and some of his schemes stretched back before then. But Cahill powerfully played off this notion of the courthouse as an embodiment of our ideals of justice, to draw the contrast with how Manton, defiled and besmirched and soiled those very ideals. So I think, Huxtable may have overstated things a bit in suggesting that having, a noble courthouse is associated with, or is even more likely to produce, noble deeds within. Maybe it is more likely. It certainly doesn't mean that that's what will happen, because whether we live up to our ideals of justice ultimately isn't a matter of brick and mortar. It's a matter of flesh and blood and what human beings do.
Absolutely. And if we can leave things for our audience with one of those illuminating tales in your book about the narrow judge's elevators in the back of that courthouse there. I will never forget the first time that I was in one of those elevators. It is small, it's tiny, it's only enough room for 1, 2, maybe 3 people if you really suck it in. And when Manton goes to his trial and his sentencing in that courthouse, what happens with those elevators?
Well, of course, he was not a judge at that point. He was an ex-judge.
Right.
But he did not quite get the memo. And so he took the judge's elevator. And when the actual judges, then on the Second Circuit, his former colleagues, Judge Leonard Hand, Judge Gus Hand, learned about that, they were absolutely livid. It was sort of the last straw for them, the final act of desecration by this judge who had done this horrible thing to the court that they loved and served for most of their lives.
Right. But that building remains a tribute to the Manton legacy, a tribute to everything folks have done in the years since to move past the Manton legacy, and a reminder to all of us.
Thanks so much for having me on. I really enjoyed the conversation and really appreciate all the work that you and the Historical Society of the New York Courts do to bring attention to subjects like this.